You are on bond for a theft, and now you've picked up another theft and an evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 13th, officers were dispatched to a theft call at Lowe's. The officer spoke to the complaining witness, who's the loss prevention officer. The loss prevention officer stated that the defendant entered the store and put a speaker into his backpack. The loss prevention officer followed the defendant around the store. The defendant walked out of the store, passing all points of sale.
Hold on.
To purchase the item.
Oh, you didn't?
Yeah.
I was going to give him a coloring book. Okay, go ahead. So he's in Lowe's?
Yes.
All right.
The complaining witness attempted to stop the defendant. The defendant did not stop. The officer was on scene when the complaining witness was attempting to stop the defendant. The officer told the defendant to stop running, and the defendant did not comply. The defendant ran approximately half a mile from the Lowe's. The officer caught up with the defendant on the third floor of an apartment complex. The defendant attempted to resist detainment. The value of the item stolen was $129. And the defendant started to run from the complaining witness towards the nearby apartment.
Mr. Castillo, I'm going to find that there's probable cause to go forward on your theft and your evading arrest. Deputy Miranda, I'm now revoking your bond on your first case. You will now go into custody. I told you not to pick up any new cases. You've picked up 2 new cases. You will now stay with me. Goes with you.
I'm sorry about that, sir.
Can you appoint him a lawyer, please? I will appoint you a lawyer now, and we'll talk, but no, you can't continue. Unacceptable. Are you Jackson Norton?
Sir,
Mr. Norton, you were charged with 2 counts of assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
February 15th, officers responded to 1025 West Mass Parkway, bar Buckwild in Harris County, Texas, regarding a disturbance. The first complainant stated that he was located at the bar ordering drinks and was in a conversation with the defendant. That's when the complainant turned around and the defendant struck him on the right side of his face. A second complainant stated that he observed that the defendant was leaning over the first complainant, physically hitting the first complainant. In an attempt to break it up, the second complainant grabbed the defendant, and the defendant turned around and punched him on the side of the head. The second complainant stated that he believed he was unconscious for multiple seconds. When he woke up, he was laying on the ground. The defendant left the establishment where his bouncers were able to locate and detain the defendant in the parking lot. A witness, the bartender, observed he saw on the second complainant. The second complainant had injuries to the left side of his face where it was pink, and there appeared to be broken blood vessels under the skin, with small lacerations near the end of his eyebrow.
Wow, this is already getting intense. The judge just revealed that Mr. Norton has 2 prior assault cases that were dismissed, and now he's facing another one. What do you think, viewers? Should past behavior influence how harshly a judge treats a new case, or should every case stand on its own?
A small amount of blood. The first complainant advised he felt pain and had a small little bump on the end of his elbow next to his eyebrow next to his hairline.
So we have 2 assaults that were dismissed early last year. Any of the complaining witnesses the same?
No, Judge.
Same set of facts, whereas alcohol as well?
The previous assaults happened at a high school graduation party.
But there was alcohol?
Yes, Judge, it's not that it was alcohol.
Mr. Norton, I'm now going to find that there's probable cause to go forward with your case. I'm now putting an ankle monitor on you so I know that you're not consuming alcohol. If I find that you do, I will put you in jail and I'm going to make your bond high. Do you understand?
yes, sir.
We're now working on our 4th, so I will do everything in my power to protect my public at all costs. Do not use alcohol, do not use illegal drugs, no weapons, no going to any bars, clubs, establishments where it's 50% or more alcohol, no going out in the middle of the night. You will get a curfew as well.
touch GPS? With Stern?
Sure.
9 to 6?
Sure, yeah.
Judge, I leave earlier in the morning for work.
I'll give you a lawyer. I'll have the lawyer talk with you, work out any kind of detail, but my concern and my only concern is the protection of my city, and I'm gonna do it at all costs.
Yes, sir.
Do you understand?
Yes, sir.
Nothing else matters to me in this life right now. If I find that you're a danger, I only have one place for you.
Yes, sir.
That right there, that line, shows how serious this judge is. Nothing else matters to me right now except protecting my city. You can really feel the emotion here. He's not just punishing, he's sending a warning. What would you do if you were the judge in this situation? Trust the defendant again or tighten the leash?
Waive all the fees, please. Mr. Norton, I'll have you fill out an application for an appointed lawyer and I'll see whether you qualify. I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you take your seat in the jury box. Do not leave until you sign all the conditions. And then I'll take a look at the application, sir.
Yes, sir.
Jackson Norton, you just gave him bond conditions, and I wanted to know if we can amend the curfew because of his work.
Okay, I knew that he had issues. What would you like?
Judge, he'd just like to remove the curfew, but keep the restriction from any bars or alcohol, or places that serve alcohol, so that he doesn't go around there. But his
So
job
what I
is-
said is he cannot go to any establishment where it's 50% or more, where there's like a true bar. If he's going to like a Longhorn Steakhouse, if he's going to, Papacitos, that's okay. But if you're going to a bar like the Marquee or you're going to, that's unacceptable. No bars, nightclubs, anything of this nature, because I don't want him to, we're working on our fourth assault now. No, and so I don't want him out in the middle of the night. I'm willing to work with you on the curfew, but
So from what he's told me, he works 8-hour shifts, but he's also he's maintenance, so he can be on call and may have to leave at 4 o'clock in the morning to get to work if there's an emergency. So he just wants to make sure that he won't be violating bond conditions if he has to go to work. My documentation that he.
right, I need proof because I'm not going to take his word for it. So bring me proof and then we can talk. But yeah, I'm not going to take his word for it that he gets up at 3 a.m. or 2 a.m. to go to this place and that place and, So, but show me something like that and then, yeah, we can work.
This moment is fascinating. The judge wants proof before giving any leniency. It's a classic courtroom balance between fairness and accountability. It makes you wonder, should a person's job flexibility outweigh public safety concerns? Drop your thoughts in the comments. Do you think he deserves that midnight pass or not?
Okay, so we'll keep the curfew in place, and then if he needs to travel for work, we can provide proof that he's clocking in and clocking out.
No contact with any of the complaining witnesses, no weapons. And then he's got the device on his ankle, so we know he's not consuming it too.
Is that a scram? Okay. So scram and GPS is what you're doing?
No, I didn't. Yeah, I guess so that we know that he's not out in the middle of the night, and if, after some time, if he's good, then we can amend the conditions as far as the GPS.
Okay.
Scram.
30 to 60 days?
Be proactive, you know what I mean? Show me, I want to know that there are not going to be any more issues, but yeah, okay. Thanks, Denise.
7 to 7?
No. I don't know. He said he had a problem with 6. I did know. What did I do? I didn't do 7 to 7.
Sorry, we're gonna do 9 to, the standard 9 to 6.
9 p.m. to 6 a.m.?
Yeah.
I think he has to be at work at 6 a.m., right?
So, yesterday?
Can you
Okay,
come
so I'll
up
do 5 a.m.
5 a.m.? 9 p.m. to 5 a.m.? Okay.
So just yesterday, I worked from 6 to 11 at night.
Yeah, I'll give 5 in the morning,
Thank you.
but don't want any more issues.
Natalie Curley, can I do midnight? Because sometimes it's 30 minutes to drive back home and I get off at 11.
Not giving you till midnight. It's not going to happen. And I want proof of anything that, as far as work is,
Requires like a
I'm not going to take your
tub or
word for
something?
it. So I need proof that, that they're actually working at this time, and then we can work on your schedule. But I'm not letting you out in the middle of the night. It's not going to happen.
Sure.
Okay. Thanks.
Judge,
9 to 5, Judge.
9 p to 5 a.m.
9 to 5, right. Yeah.
So we're gonna amend this.